afternoon. It's another time with the Enthusiastic Tutor. I welcome you all on board. Today, we'll be taking the course CSS112. Actually, the continuation of the course. We had one class already on this course, and it's all about law. It's actually the sociology of law, and we've been dissecting, all right, sociology of law. In our last class, we talked about different definitions from different scholars, and today we're going to be specifically we're going to be niching down to law itself and what it has to do in the environment, in the society at large, if it has been more of help or more of a decadence to the society. All this we're looking at. We're going to be looking at some sources of law, and we'll be dissecting all that in this class. All right. With this being said, for as many of us who are just hopping on this video for the very first time, let's go to subscribe to the channel. Let's go to share the video. And if you want more of your courses, recorded version of your courses, we have it all on the website. Check the description of this video, www.tutorial.com. You go there and find all your classes there. All right. And we also have a private class where a lot of things go down. A lot of things like personal tutelage, all right, exam keynote, practice questions, exams, practice questions and answer. All this just to enhance smooth study and help you get better in your program. All right. With this being said, let's hop straight into it. So I have CSS112. Okay. Today we'll be talking about defining law. Okay. Defining law. The phenomenon, all right, the phenomenon term as law is what? Extraordinary complex. In a word, let's tag word law as command. All right, command of command of what? Command of sovereignty. Now, just like as I said earlier on, the term is complex, and when we say command of sovereignty, there's a lot attached to it. Now, let's look at John Austin's definition. Now, John Austin happens to be a lawyer and defined law as a rule, all right, laid down for the guidance of an intelligent being by an intelligent being having power over him. Now look at the point here. That's John what? John Austin. To his own version of the definition of the term law, he said that law is a rule laid down for the guidance. All right, rule laid down for what? Guide. All right, laid down for what? For guidance of an what? Intelligent being having power over him. It's a rule laid down as a guidance. All right, guidance laid as a guardian of an intelligent, all right, intelligent being, all right, laid down as a guidance by an, supposed to be by, not of an, by an intelligent being in order to what? Having power over him. Now, let's take note of some certain things. Now, what are the key points? The key point here is that, please let's pay attention to this. We have rule underlined. Let me get a better shade of the marker. Okay, that is fading already. Okay, we have rule, we have guidance, we have power. All right. Now, rule, meaning that a guide. Why do we have rule? To what? To act as a deterrent. All right. To act as a barricade. All right. To act as a what? Deterrent, or as a barricade, or what? As a fence, indicating that this is what is expected of you. If you do this, you get this. A fence in the sense that this is your stopping point. You don't go beyond this. In this case, you don't go beyond this. This is your control. Just like we have switches in the house, whereby you switch on and switch off your electricity bulbs, your sockets, or your power supply. Rule, a guide. All right? Not just a guide, not just a rule, but one that is what? Sovereign. All right? Not just any kind of rule or guide. We can have guide, we can have rules, but they might not be sovereign. All right? So the rule, the guide, that is what? Sovereign. Okay? That is according to John Austin, who happens to be a lawyer. Now, so his definition, all right, his definition, the definition of John, all right, conforms to the what? Imperative or command theory of law. All right? Command theory of law. Now, let's see what John Salmond also said. John Salmond also said something. All right? John Salmond. Now, John Salmond says that law, he sees law as a body of principles. Now, these principles recognized and applied by the states in the what? Administering of justice. He says it as what? A body of principles. A body of principles. All right? And this body of principles is recognized, all right, is recognized and applied by the states, all right, in the what? In the process of administering justice. So in this case, it is the responsibility of the state to administer justice. And in so doing, it has to put into order, it has to put into place what we refer to as checks, all right? It has to put into place what we refer to as deterrents. It has to put into place what we refer to as pointers. Okay? So now that's why he said it's referred to as a principle of what? Recognized and applied. Principles of recognized and applied what? Principles of a body of principles that is what? Principles that are what? Principles recognized, these principles are recognized and applied by the states in what? In administering. Administering. Administering what? Justice. Alright? So, body of principles, recognition, alright, and applied by who? The state. Alright? In justice. So we have that as that. So now let's proceed. Now, just like what we said before, we said it's extraordinary, what? Complex. It's actually very complex. The complexity of this term, all right, is extraordinary. Now, law is a complex whole of many phenomena. All right, it is a complex whole of what? Many phenomena. All right. A lot of things are involved when we talk about this term. All right, a lot of things are involved. Okay, now a lot of things in the sense that this phenomena that we are seeing here includes norms regulating behavior. Norms regulating behavior. Okay, it doesn't end there. Okay, and it also serves what? The machinery for the enforcement and administration of these norms. Machinery, all right, for the enforcement and administering of the norms. You see why it is very, very complex. It does not just serve as a regulating body. It's also responsible. The same you that create is the same you that are still responsible for the enforcement and the proper administration or proper administering of what you orchestrated. All right, that's why we said its complexity is extraordinary. All right, now let's proceed. Now you should know as well that norms that what constitute the law are social in character. Let's take note of that. Norms that constitute the law is actually social in character. Now the norms that constitute the law, all right, present an orderly picture of the society in which the norms operates. Okay, it has to present an orderly picture of the society in which the norms operate. Now, enough being said on this, let's move straight to the sources of law. Permit me to quickly erase this. The sources of law. The sources of law. Now, the sources of law. Okay. Now, the sources of law are the materials from which legal rules are made. The materials okay, the materials for which legal rules are made. Okay, the sources of law are the materials for which legal rules are made. Now, such materials include custom, religious belief, morality. All right, that is custom, all right, religious beliefs, all right, moralities, moral, all right, or morality, habits, all right, folkways, and much more. Morality, habits, folkways. That's folkways, folk ways, whether written or not, and so on. Now, sometimes the word source is not used in what? Inference to material from which laws are formed alone. All right? But also reference to the manner in which laws are made. I don't know if we get that. Now, sometimes the word source, okay, is not used to make reference. All right? Is not used to make reference to the material. It is not limited to the reference of the material at which a particular law is being created, but as well as it is in reference to the manner, all right, what brought about the creation of this law, to the manner in which the law is made. Now, legislation, codification, judicial precedents, and equality. Now, all these ones I'm making mention of now, they are the manners. All right, you can categorize them under the manners. Like all these ones now are more of the materials, and we have source like the manners. All right, we have codification. All right, we have judicial. All right, judicial, that should be judicial precedent. All right, codification, judicial precedent, legislation, equality. We have legislation, and we have that should be equity, not equality. Equity. Okay, are also what? Sources of law. Now let's proceed. Now, when we talk about legislation, what are we talking about? Legislation here simply talks about this is the law that results from activities of enacting body, such as the legislature. All right, all right, legislature. All right, activities of what? Of the law, all right, from the enacting body, responsible by the enacting body of law, the legislature. legislative. All right. They also refer to as the group of people usually representing the surveying seat. All right. To what consciously deliberate and enact laws which we say today as they are legislating. All right. So we also have that as that. We have the custom and judicial precedents. This is quite straightforward. Custom combined with decisions of judge, all right, in decided cases, all right, of the past constitutes a source of law, especially in common law countries. Now, when we say judicial precedents, all right, for culture and custom and judicial precedents, just like in Yoruba land now, you are not expect, especially women, you are not expected to come out when some traditional stuffs like oro is going on. All right, if you as a woman, if you happen to come out, that means you flaunt that law, and you know in a case like that, definitely you will face the wrath of the law. And if it happens to be that the judge was able to bring it out a point or two and you were not punished on a reasonable count charge, or let me say on a reasonable evidence being provided. So that's actually an exception. In a case like that in the future, if such a case repeats itself, reference will be made, all right, unless if the reasons given supersedes the decision of the judge. All right. So judicial precedent is just like, okay, the judge or the decision that a judge gave in a particular case, all right, in a peculiar case in previous years, in the future, in a future occurrence of such case, reference are being made to that past decision to judge even a recent case. That's what we refer to as judicial precedent. And if it's construed like that, then it becomes a law. All right. So that is for judicial precedent. We have equity. All right. It is all right. In a simple sense, it means fairness and justice, equality. Everybody is equal before the law. All right. Equity, fairness, and justice. All right. Equity. Fairness and justice. Equity, fairness, and justice. And we have subsidiary sources. Now, these include writings and commentaries by legal scholars. All right, that is subsidiary sources. Subsidiary sources, writings and commentaries. Writings and what? Commentaries. All right, writings and commentaries by legal scholars. By what? Legal what? Legal scholars. So we have that as that. So countries like Germany, France, Italy use this a lot, subsidiary sources. And under the Islamic law, right, this is also very, very cogent. It's also very, very big about. It's actually highly observed. Okay, so we have classifications of law now. Let's talk about the classification of law. So under the classification of law, we have classification. Okay, we have class of law. 1, 2, 3, 4. Now we have the criminal law. Criminal law. We have the civil law, criminal law, criminal law. We have the civil law. Okay. We have substantive law. We have procedural law. Okay, all these we're going to talk about in a moment. Now, for the criminal law, this is referred to those aspects of law dealing with what? Offenses or crimes. All right, deals with offenses / crime. Okay, that are punishable by the state. Punishable by the state. Okay, it's a part of the law that has to do with criminal or crime or offenses punishable by the state. Now, civil law, on the other hand, here, civil law says, all right, the laws governing conduct, all right, this is the law governing conduct, and it's actually not punishable by the state. Laws governing conduct. Governing what? Conduct, and is not punishable, all right, by the states. Okay, we have substantive law. Now, this law refers to the bodies of law which defines offenses and prescribe penalties for violation. All right, defines offenses and what? Prescribe what? Penalties. It prescribes penalties. It prescribes. It does not only define, but it also it prescribes penalty for violation. Penalties for what? Violations. Okay, and we have number 4. Now, this substantive law, it also defines rights and duties. And examples of substantive law, all right, is what we have as code and the panel code. Code and the panel code. That is the example of substantive law. Now we have procedural laws, which prescribes procedures. Procedural laws, it prescribes procedures that must be followed in the prosecution of offenders. All right, it prescribes procedures to follow when persecuting an offender. Okay, so we have that as that. Now, let's talk about the function of law. Then we'll call it a wrap for today. Okay? Function of law. Now, let me erase this very quickly. What are the necessities? Why do we have laws? What are the necessities, all right, of having laws guiding the activity, all right, of the state? Now, we have functions. Now, we have the very first function is that it preserves the existing what? It preserves the existing of what? The legal system. Just a moment. Now, let's take note of this. It maintains peace and order. Maintains peace and order. All right? It provides the what? Redress of harm done on individuals. All right? It's a prerequisite for man to realize his potentials in any society. Right? The law is able to perform this function more effectively through the branch of the criminal law. All right? It fights for people who can fight for themselves. All right? It provides redress for broken agreements as well, protection for of basic freedom of individuals, also protection and reinforcement of family relationship. These are just few among many others that we're going to be mentioning in this class. So in our next class, we're talking about, all right, how necessary is the law in society, all right? Has it been more of harm or good, all right? So thank you very much, everyone. I hope we've been able to gain a thing or two in this class. Let's do also bring our notes up to date. Let's send a photo of our notes to the classroom, our respective classes. Thank you very much, everyone. I look forward to seeing you in subsequent tutorials. Bye-bye.